court. You are going to have copies of the decisions.
As God pleases.
Thank you. Hello, can you hear me?
I can hear you, my Lord.
Oh, okay, thank you.
Yes,
So,
we
Mr.
can hear
Can
you.
call the first case for judgment?
Yes, my Lord. Resume today, Friday, 30th September 2022. Before His Lordship, Honorable Justice P.I. Herman, put number 9/PX/130, 2019. Mr. Abara Sonny Pepu and C&I Petrotech Marine Limited. Our parties are absent.
Yes, counsel, who appears for the claimant?
Mr. Tokwe is still struggling to join.
Okay, he's here to join us.
No, he joined. I think he's having some network issues. He will come and go off. I can see his icon struggling to join.
Oh, okay. Okay, Mr. Wilson, let me take your appearance so that we can proceed.
As the court pleases. My Lord, with utmost humility. My name is Wilson. Okay.
Yes.
I humbly appear for the defendant.
This is the court's decision. I hope you can hear me, Mr. Okay.
Yes, my Lord.
Okay, this is my decision. This complaint, together with the statement of facts and other accompanying processes, was filed on the 23rd of October 2019, wherein the claimant claims the following release against the defendant. 1, a declaration that the purported termination of the claimant's employment on the 6th day of February 2019 by the defendant is wrongful, unwarranted, null and void. 2, a declaration that the claimant's employment with the defendant be restored in accordance with the defendant's employment offer dated 9th of September 2011 and confirmation of appointment dated 20th day of June 2012. 3, a declaration that the claimant is entitled to all the arrears of remunerations from the defendant from the 6th day of February 2019 to the determination of this suit. And 4, a declaration that the claimant is entitled to the sum of 50 million naira only as general and consequential damages for the unlawful termination of the claimant's employment. Upon receipt of the originating processes, the defendant filed memorandum of appearance, statement of defense, list of witnesses, witness statement on oath, list of documents, and frontlotted documents on the 13th of January 2020, which were, however, deemed by the court on the 6th day of February 2020. with the leave of court granted on the 6th of December 2021, the defendant's written statement on oath of Roland David was deemed as having been properly filed and served, while the entire evidence of the first witness called by the defendant, Oluchi Okonkwo, was withdrawn and expunged from the court records. Trial in this suit started on the 10th day of February 2021, when the claimant opened his case by testifying for himself as CW. The witness affirmed to speak the truth before he identified and adopted his statement on oath filed on the 23rd day of October 2019. The following documents were then tendered through the claimant and admitted by the court. 1. Letter from the office of the Amayanabo of Boni, dated 31st of January 2019, was admitted under protest and marked as Exhibit CW1A. 2. Offer of employment, dated 9th of September 2011, Exhibit CW1B. 3. Letter of confirmation of appointment, dated 20th June 2012, Exhibit CW1C. 4. Letter of review of remuneration, dated 1st of July 2018, Exhibit CW1D. And 5. Letter of termination of employment, dated 6th of February 2019, Exhibit CW1E. The witness was cross-examined by the defendant's counsel, and 2 documents, which are the letter of the Amayanabo of Grand Boni, dated 30th June 2011, and C&I Leasing PLC internal memo, dated 19th of December 2016, were admitted as Exhibit CW1F under protest and CW1G respectively. The witness was discharged on the 4th of March 2021 without any re-examination. The claimant closed his case on the 4th day of March 2021. The defendant opened his defense on the 6th of December 2021 by calling his sole witness Roland David, who testified as DW. The witness swore on the Holy Bible before he adopted his statement on oath made on the 8th of November 2021. And 1 document, which is evidence of alleged payment of terminal benefit, was tendered through the witness and admitted as Exhibit DW1A. The witness also identified Exhibits CW1D, CW1E, and CW1G as the other documents he referred to in his deposition. The witness was cross-examined by the learned counsel to the claimant and discharged on the 6th of December 2021 without any re-examination. The defendant closed his defense on the 6th of December 2021. It is pertinent to point out that the entirety of the evidence of the defendant's first witness, Oluchi Okonkwo, who testified on the 4th of October 2021 and partly cross-examined by the claimant's counsel, was withdrawn by the learned counsel to the defendant, Wilson Oke, and expunged from the records of the court on the 6th of December 2021. When the matter came up on the 5th day of July 2022 for adoption of final written addresses, O.O. Oshadola appeared for the claimant, while Wilson Oke appeared with U.A. Edward for the defendant. Parties thereafter adopted their final written addresses. The defendant's final written address, dated 17th of December 2021, was filed on the 30th day of December 2022, but deemed on the 17th of May 2022. The defendant filed a reply on points of law on the 16th of February 2022. Now the case of the claimant. The claimant averts that he was employed by the defendant as a personnel officer with effect from 13th of October 2011, and the employment was confirmed with effect from 12th of April 2012. That on the 1st of July 2018, his remuneration was reviewed from 3,401,748 naira 42 kobo to 3,912,004 naira 93 kobo. That despite his unblemished record and outstanding performance, his employment was terminated on the 6th of February 2019 by C&I Leasing PLC, which is a company different from the defendant, who is his employer. That upon several inquiries, he discovered that the termination of his employment was based on the letter from the office of the Amayanabo of Boni, dated 31st of January 2019, which recommended one Juliet Atonye Ogbekilu Ni Jumbo to the defendant as a new personnel officer. The claimant attributed the letter signed by the Palace Secretary as a revenge due to some disagreements in the Boni Chiefs Council, because he is the secretary of King Fubara Manila Pepu, House of Boni, that he has on several occasions resisted attempts to derecognize his house chief or head of Se Alabo Aminioga Owen Manila Pepu, Lieutenant Colonel retired, as a member of the Boni Chiefs Council, because there is a pending court case on the matter. According to the claimant, the termination of his employment on the basis of the letter from the palace is without due process of law and the terms and conditions of the contract between the parties, and also that the claimant was employed by the defendant and not C&I Leasing PLC that terminated the employment contract. That since employment is to be terminated upon the expiration of the SPDC contract upon which he was employed, the employment subsists because the said SPDC contract given to the defendant is still running. Now, defendant's case. The defendant averts that he employed the claimant and transferred his services to Marine Department of C&I Leasing PLC with effect from 1st January 2017, where he enjoyed all the accrued benefits, including upward review of his remuneration, and ceased to be an employee of the defendant. That the claimant's employment was terminated by C&I Leasing PLC on the 6th of February 2019, and he was paid his terminal benefits in line with the terms of the employment. That even though the defendant exchanged several correspondences with the host community, the defendant does not interfere in the activities of his host community, and the defendant, not being a member of the Boni Chiefs Council, is not aware of any alleged infighting and retaliation in the Boni Kingdom. According to the defendant, either party has the right to terminate the contract of employment with 1 month notice or salary in lieu of notice, and the claimant was paid the sum of 396,055 naira 59 kobo as his terminal benefits. Now, defendant's submission. The learned counsel to the defendant submitted these 2 issues for the determination of the court. 1, whether there was the master and servant relationship between the claimant and C&I Leasing PLC as at the 6th day of February 2019, when the claimant's employment was terminated. And 2, whether the termination of the claimant's employment on the 6th day of February 2019 and the payment of 1 month salary in lieu of notice was wrongful. It was submitted on the 2 issues which were argued together, that since the reliefs in this suit are declaratory in nature, the onus of proof is on the claimant, who is to discharge same on the balance of probabilities. Learned counsel referred to sections 131 sub 2 and 136 sub 1 of the Evidence Act and the case of Mini Lodge versus Ngai. Citation is provided. Learned counsel reproduced paragraphs 6, 7, and 10 of the statement of facts, and paragraphs 2134 and 3133 of the statement of defense, as well as paragraphs 2, 5, 8, 9, 11, 12, and 13 of the defendant's witness statement on oath, filed on the 8th day of November 2021, and exhibit CW1G and CW1D, and submitted that the claimant became an employee of C&I Leasing PLC from the 1st of January 2017, where he enjoyed all the benefits and cannot not turn a vote face. That the failure of the claimant to file a reply to paragraphs 2 sub 1 and sub 3 and 4 and paragraph 3 sub 1, 2, and 3 of the statement of defense, that the claimant became an employee of C&I Leasing PLC which led to the review of his salary and other entitlements, is an admission. Counsel referred to Answer versus Into. Citation is given that where a person works for another and is subject to the control and direction of that other person, there is a master and servant relationship between them. That in law, a master and servant relationship can be terminated at any time, even without any reason. That even where the master terminates the employment summarily or by giving insufficient notice, the employment is nevertheless effectively terminated. On this, counsel referred to Coca-Cola versus Akinsanya, ESO versus Ali, Jingba versus UBN, and Gaidam versus NEPA. Citations are all provided. The learned counsel to the defendant further referred to Exhibit CW1B and DW1A and posited that since the claimant's employment was terminated with payment of 1 month's salary in lieu of notice, the employment was properly terminated and the claimant cannot be held to complain. Counsel referred to Obanye versus UBN Nigeria PSC and Chukuma versus Shell Petroleum Development Company. Citations are provided that the employment of the claimant was lawfully terminated on the 6th of February 2019, and he is not entitled to the claims before the court. The court was urged to resolve the 2 issues in favor of the defendant and dismiss the suit. Now, claimant's submissions. The learned counsel to the claimant submitted 1 issue for the determination of this court, to wit, whether from the totality of evidence adduced and surrounding circumstances of this case, the claimant is entitled to the relief sought in this case. The learned counsel argued on the loan issue that a claimant who seeks a declaration that his contract of employment has been wrongfully terminated must prove that he is an employee of the defendant and also the terms and conditions of the employment. Counsel referred to SPDC versus Adiko and Ogundipe versus Nigeria Telecommunications Limited, as well as UBN Limited versus EDET. Citations are given that the burden is on the claimant to prove that the termination was wrongful, and by Exhibit CW1B and the evidence on record, the claimant has shown that he was employed by the defendant and not C&I Leasing PSC that terminated his employment. Counsel referred to Nigerian Gas Company versus Dudu Solar and Omar versus Lombarger, Nigeria Limited. Citations are given. It was further argued that since the claimant's pleadings and evidence were not challenged by the defendant, the court should rely on them in this suit, referring to the case of Omemu versus Commissioner for Agriculture, Delta State. Citation is also provided. That the oral testimony of the defendant's witness on the 6th of December 2021 to the effect that Exhibit CW1G replaced Exhibit CW1D, which contains the terms and conditions of the contract of employment, cannot be used to vary the content of the said exhibits. Counsel referred to Owoye versus Oyinlola, that in law, it is only the parties to a contract that can enforce it, and not someone who is not a party to it, even if the contract is made for the person's benefit, and also that only the person that hires can also fire. Counsel referred to New Resources International Limited versus Oranusi and UBN versus Suarez. Citations are given. That from Exhibit CW1E, the claimant's employment was not terminated by the defendant, who is his employer, but by C&I Leasing PSC. It was further argued that where the court finds that the claimant's employment was wrongfully terminated, he is entitled to be restored or paid all requisite allowances, that the court should compensate the claimant with heavy damages against the defendant for wrongful termination of his employment. Counsel referred to FMC Ido-Ekiti versus Alabi, WNDC versus Abimbola, Ogundipe versus Nigeria Telecommunications Limited, Osisanya versus AfriBank Nigeria PLC, and Okuneye versus Lagos State City Council. Citations are all provided. That the defendant is only trying to rely on his address to prove his case, rather than the pleaded facts and the evidence adduced in the suit, relying on the case of NEPA versus Savage. Citation is also given. It was further argued that the submission of the defendant that the claimant did not file reply to the statement of defense and is therefore taken to have admitted the averments in the statement of defense is untenable in law because there is no need to file reply to a statement of defense that has not raised any new issue. That the statement of defense in this suit did not raise any new issue to warrant filing the reply to the defense. Counsel referred to Ona versus Okam and Achiluhu versus Ayantowu. Citations are provided. The court was urged to resolve the loan issue in favor of the claimant, enter judgment in his favor, and grant all the reliefs in this suit. Now, defendants reply on points of law. It is pertinent to note that the defendant filed reply on points of law on the 16th day of February 2022. With respect to the claimant's argument at paragraph 2.9, page 2 of the claimant's final written address, that the defendant's DW1 Oluchi Okonkwo was foreclosed by the court from further testifying in the matter before the defendant called DW2, Mr. David Roland. It was replied that the court did not foreclose Oluchi Okonkwo, but her evidence was withdrawn by the defendant's counsel on the 6th of December 2021 due to her health challenges, which caused her to be absent from court. Now, it is pertinent to state that I have seen the court records, and I agree totally with the defendant's counsel that Oluchi Okonkwo was never foreclosed from further testifying in this suit. The witness, Oluchi Okonkwo, commenced her testimony on the 4th of October 2021 and was cross-examined in part by the claimant's counsel before the matter was further adjourned to 9th of November 2021 for further defense. On the 6th of December 2021, the learned counsel to the defendant informed the court of the inability of the witness to be in court due to ill health and applied to withdraw the entirety of the evidence already given by the witness. The application was granted, expunging the entirety of the evidence already adduced by Oluchi Okonkwo from the court record without any opposition from the claimant's counsel, Tope Duyilemi, who was present in court. The defendant's counsel did move the defendant's motion on notice for leave to call an additional witness, which was filed on the 8th of November 2021, which was also granted without any opposition from the claimant's counsel. The defendant then called a substitute witness, Roland David, who testified on the same 6th of December 2021. It is therefore not correct that the defendant's witness was foreclosed from further testifying in this suit. With respect to the claimant's argument at paragraph 2.3 and 4.3, pages 1 to 3 of the claimant's final written address, that the claimant's remuneration was reviewed upward due to his outstanding performance, and also that the claimant is an employee of the defendant and not C&I Leasing PLC. It was replied that from Exhibit CW1D, the claimant's remuneration was reviewed by C&I Leasing PLC and not the defendant, and that by Exhibit CW1G, the claimant's employment was transferred to C&I Leasing PLC from the defendant with effect from 1st of January 2017, that the claimant was an employee of C&I Leasing PLC when his employment was terminated on the 6th day of February 2019. On the argument at paragraph 4.18, page 5 of the claimant's final written address, that the termination of his employment was wrongful because the contract is only terminable upon the termination of the SPDC contract upon which he was employed. It was replied that in common law and by Exhibit CW1B, the 1 month salary paid to the claimant in lieu of notice made the termination lawful and valid. Counsel referred to Porter versus Nestle Products Nigeria Limited. Citation is given. On the argument at paragraph 4.20 and 4.21, page 6 of the claimant's final written address, that where the court finds that the termination of the employment is wrongful, the claimant should be restored to his employment and all relevant allowances paid to him. It was replied that the claimant is not entitled to reinstatement because his employment is not one with statutory flavor. Counsel referred to Gedan versus NEPA and Obanye versus UBN PSC, Supra. On the claimant's argument at paragraphs 4.22, 4.23, and 4.24, page 6 of the claimant's final written address, that he is entitled to award of heavy damages, it was replied that the case of Osisaya versus Afribank Nigeria PLC Supra, cited and relied upon by the claimant, must have been cited by the claimant in error because the case supports the case of the defendant. The court was urged to dismiss the suit. It may be apposite to state that the contention of the defendant in paragraph 1.05, page 3 of the reply on points of law, that the claimant's counsel wrongly cited the case of FMC Ido-Ekiti versus Alabi instead of FMC Ido-Ekiti versus Kolawole may not be correct because I have checked and discovered that apart from the case of Federal Medical Center, Ido-Ekiti and others versus Omidiora Kolawole O, which was decided by the Court of Appeal, Ado-Ekiti Judicial Division on the 14th of July 2011 in appeal number CA/AE/24/2010. There is also the case of Federal Medical Center, Ido-Ekiti and others versus Shaib Adewole Alabi, which was decided by the same Court of Appeal, Ado-Ekiti Judicial Division on the 24th of March 2011 in appeal number CA/EKT/23/2010. I therefore hold that the said authority is in existence, contrary to the contention of the defendant's counsel. Now, court's decision. Having poured over the pleadings, evidence, and submissions of both learned counsel to the parties, this suit shall be determined on the basis of the loan issue submitted for determination by the claimant's counsel. The said issue is whether, from the totality of the evidence adduced and the surrounding circumstances of this case, the claimant is entitled to the relief sought in this case. It could be recalled that at the hearing of this suit, on the 10th day of February 2021 and 4th of March 2021, when parties sought to tender Exhibit CW1A and CW1F during the claimant's evidence in chief and his cross-examination by the learned counsel to the defendant, both learned counsel indicated their desire to object to the documents in their respective final written addresses. Hence, the documents were admitted under protest and marked as Exhibit CW1A and CW1F respectively. I have, however, perused the written addresses of both parties in this suit and have not seen where both counsel raised any issue regarding the admissibility of the said exhibits. I therefore take it that both learned counsel have no intention of objecting to the admissibility of the evidence of the exhibits, and that being the case, the said exhibit CW1A and CW1F shall be containers in this suit. Now, with respect to the loan issue identified by the court for determination in this suit, I have seen that in the bid to prove his case as required by law and discharge the burden of proof on him, the claimant testified for himself via his deposition filed on the 23rd of October 2019 and tendered Exhibit CW1A to CW1E. During his cross-examination by the learned counsel to the defendant on the 4th of March 2021, the claimant answered that he knows C&I Leasing PLC, but he is not aware that the defendant C&I Petrotech Marine Limited was a subsidiary of C&I Leasing PLC. He affirmed knowing Exhibit CW1F, upon which himself, Mr. Austin Onu Pepu and Mr. Idopu C. Halliday were employed by the defendant. He affirmed that Exhibit CW1F was not addressed to the defendant, but to C&I Leasing PLC, and the name of the defendant is not mentioned in Exhibit CW1F. He also affirmed that in the course of his employment, several memos were either pasted or given to him, which is signed and collected, and that Exhibit CW1G is one of such internal memos. He refuted the insinuation that Exhibit CW1G transferred his services from the defendant to C&I Leasing PLC because C&I Group comprises of C&I Marine, C&I Petrotech, and C&I Leasing, which are distinct companies, but owned by the same person. That he was employed by the defendant, who then contracted the payment of his salary to C&I Leasing PLC, but that his employment was not taken over by C&I Leasing PLC because he was not given any new letter of employment by C&I Leasing PLC, that to his knowledge, he was the only one in his location at the Bonny SPDC terminal whose employment was terminated on the basis of the letter from the Bonny Chieftaincy dated 31st of January 2019, but delivered on the 6th of February 2019. He affirmed that since the Bonny Chief Council is a traditional council, C&I Leasing PLC is not part of the said council. The defendant on her part called one Roland David, whose evidence in chief is as contained in his statement on oath filed on the 8th of November 2021. The defendant tendered exhibit DW1A and exhibit CW1F to CW1G through the claimant during the cross-examination of the claimant. The defendant's witness also identified exhibit CW1D, CW1E, and CW1G as the other documents he referred to in his statement on oath. During the cross-examination of the defendant's witness, he answered that he is not an employee of the defendant because the company went into extinction on the 31st of December 2016. And prior to that, all the staff of the defendant were taken over by C&I Leasing PLC, and he is speaking for C&I Leasing PLC. He, however, informed the court that he has no document from CSC or any court showing that the defendant no longer exists. He stated that he has a letter of employment from C&I Leasing PLC, but affirmed that C&I Leasing PLC is not a party to this suit. That by exhibit CW1G, C&I Leasing PLC took over the staff of the defendant. He affirmed that there is also C&I Marine, which is also a registered company under KAMA. That apart from the exhibit CW1G, there is a remuneration review, which the claimant also acknowledged, and that the terms of employment are the same. He finally affirmed that the last paragraph of exhibit CW1G makes reference to exhibit CW1B. Let me restate for the sake of emphasis that the onus of proof is on the claimant, who is alleging wrongful termination of his employment. He is to prove his case by producing before the court the terms and conditions of the employment, and also show how the defendant contravened the said terms and conditions in bringing the employment to an end. This is in line with the legal position that he who asserts must prove, particularly that in this suit, all the four reliefs are declaratory in nature. The claimant must succeed on the strength of his case and not rely on any weakness in the defense, since the reliefs cannot be granted even on an admission or default of pleadings. See sections 131, 132, 133, and 134 of the Evidence Act, and also the cases of Adesoye, Olanlege versus Afro-Continental Nigeria Limited, Dr. Tunde Bakoye versus University of Ilorin and another, Nigerian Romanian Wood and another versus J.O. Akin Bulugbe, and Dr. Ben O. Chukuma versus Shell Petroleum Development Company of Nigeria Limited. Citations are all provided. It is apposite to state that from the state of pleadings and evidence on record, the claimant was employed by the defendant via exhibit CW1B, dated 9th of September 2011, sequel to exhibit CW1F, which is a letter of recommendation from the Palace of the Amanayabo of Grand Bonny, dated 30th June 2011, and addressed to the project manager of C&I Leasing PLC. The appointment of the claimant was confirmed with effect from 12th of April 2012, via exhibit CW1C, dated 20th June 2012. In the absence of any staff condition of service of the defendant before the court, it is obvious that the terms of the claimant's employment are as contained in the letter of employment exhibit CW1B, and this court shall be guided by the said terms in determining the issues in contention in this suit. The rationale for this is that in law, and particularly employment matters, parties are generally bound by the written terms and conditions of agreement voluntarily entered into, and no other evidence should be allowed to add to, vary, or alter the said terms and conditions contained in the written contract. In the case of Mrs. O. Olayade versus Panapina World Transport Nigeria Limited. The Apex Court, by Yekini Olaiwola Adio JSC, put the issue aptly thus at page 22, paragraph D to F of the law report. And I quote, the general rule is that where parties have embodied the terms of the agreement or contract in a written document, as it was done in this case, extrinsic evidence is not admissible to add to, vary, subtract from, or contradict the terms of the written instrument. Olaloye versus Balogun, Union Bank of Nigeria Limited versus Ozigi. So where the parties enter into a contract, they are bound by the terms of that contract, and it is unfair to read into such a contract the terms on which there was no agreement. Abdullahi Baba versus Nigeria Civil Aviation Training Center, Zaria, and another. End of quote. See also the cases of Mr. Elias Kaza versus Alaji Aliu and Share Petroleum Company Nigeria Limited versus Mr. F.O. Emehuru. Citations are also given. I have seen that Exhibit CW1B provides for termination thus at page 3, and I quote, upon confirmation, either party shall give at least 1 month notice of their intention in writing or pay 1 month gross salary in lieu as benefits. It is further agreed that notice period shall not be offset against accumulated leave, nor payment be accepted in cash for any short notices in lieu or part thereof, unless otherwise agreed by the company in writing. Your services are terminable by the company upon expiry/termination of SPDC contract upon which you were employed. End of quote. It is in evidence that by the tenor of the termination letter, dated 6th of February 2019, Exhibit CW1E, the employment of the claimant was terminated with immediate effect, implying that no notice of termination was given to the claimant prior to his disengagement from the defendant. The defendant's contention is that while it did not give the claimant the required notice of termination, it however adopted the option of paying the claimant the agreed 1 month salary in lieu of the requisite notice. The defendant clearly pleaded in paragraph 2 sub 4 of the paragraph 2 sub 5 of the statement of defense, and also informed the court via paragraph 7, 8, and 9 of the defendant's witness statement on oath of Roland David that upon the termination of the claimant's employment, he was paid the sum of 396,055 naira 59 kobo as 1 month salary in lieu of notice in February 2019. The claimant did not deny that he was paid the said amount as salary in lieu of notice of termination, and no effort was made by him to challenge this vital piece of evidence. He neither filed any reply to the statement of defense nor cross-examined the defendant's witness on the evidence with a view to controverting or challenging the evidence. That being the case, the law is right that he is deemed to have admitted that the payment of the said amount to him was salary in lieu of notice, and this court shall accept and act on the said evidence. See Nigerian Army versus Warrant Officer Bani Yakubu. Citation is given. It is apposite to state that by Exhibit CW1D, the claimant's remuneration was reviewed upward from 3,401,748 naira 42 kobo to 3,912,004 naira 93 kobo, with effect from 1st of July 2018. And by Exhibit DW1A, the claimant was paid the total sum of 396,055 naira 59 kobo, out of which the sum of 311,330 naira 42 kobo is the claimant's 1 month gross salary in lieu of notice. I therefore hold that having paid the claimant salary in lieu of notice as agreed by the parties in the Exhibit CW1B, there is no basis to adjudge the termination of the claimant's employment as wrongful. I so find and hold. See Babatunde Ajayi versus Tezaco Nigeria Limited and others, and Mrs. O.O. Layade versus Panapina World Transport Nigeria Limited. Citations are given. the claimant has contended strenuously that the termination is wrongful because the termination letter was issued by C&I Leasing PLC and not the defendant, C&I Petro Marine Limited, that employed him. I have seen that even though by exhibit CW1B and CW1C, the claimant was employed and confirmed by C&I Petro Marine Limited and not C&I Leasing PLC. It is, however, in evidence that the letter recommending the claimant for employment, exhibit CW1F, was addressed to C&I Leasing PLC, and the upward review of his remuneration was carried out by C&I Leasing PLC. The claimant enjoyed enhanced salary from C&I Leasing PLC from 1st of July 2018 to 6th of February 2019 without any qualms. In addition, by exhibit CW1G, the claimant was informed of the collapse of the defendant's structure and his movement into C&I Marine effective 1st of January 2017, and he did not raise any eyebrow. He cannot therefore claim to be unaware of C&I Leasing PLC that received the recommendation for his employment and paid him enhanced salary or remuneration from 1st of July 2018 till the termination of his employment. Another contention by the claimant is that exhibit CW1A spurred the termination of his employment because of alleged crisis in the Bonny Chiefs Council, which led to the recommendation of one Juliet Atonye Ogbekilu to the defendant. The court's opinion on this contention is simply that exhibit CW1A was addressed to C&I Leasing PLC and not the defendant. That is, if the claimant's argument that he was not employed by C&I Leasing PLC is anything to go by. And also that there is no indication in the document that the said Juliet Atonye Ogbekilu was to take over the position of the claimant in the defendant. There is also nothing before the court to show that the company acceded to the request of the Amaneabo of Bonny and employed the said Juliet Atonye Ogbekilu. I heard earlier in this judgment that since all the 4 reliefs being claimed in this suit by the claimant are in the nature of declaratory reliefs, he must succeed on the strength of his case and not rely on any alleged weakness in the case of the defendant. The reliefs before the court are not such that can be granted for the asking. The claimant is by law required to still place sufficient and convincing evidence before the court, even in the face of admission or default of pleadings on the part of the defendant. I cannot fathom how in an employment matter, as the instant one, a claimant will ask for only declaratory reliefs without asking for any specific order from the court. It is obvious that the claimant has failed to discharge the honors of proof placed on him by law. The suit therefore lacks merit, and same is hereby dismissed for want of proof. Judgment is entered accordingly, and I make no order as to cost.
My Lord, we want to commend my Lord for the noble judgments. Sorry, my Lord, I came behind schedule. I am O.O. Oshadola for the claimant. As the court pleases, sir. As the court pleases, my Lord. Yes, my Lord, sir. For the claimant, sir. My Lord, indeed, we are grateful for a well-considered judgment, sir.
Thank you.
Most grateful, sir.
Thank you.
Yes, sir.
So you have copies of the judgments as soon as I get back to Port Harcourt.
As the court pleases, sir. As the
Yes,
court
we are
pleases.
having our legal year in Abuja next week.
Okay, my Lord, sir. Okay.
All right,
I wish my Lord safe. Most grateful, sir.
Thank you. Thank you.
Yes, my Lord. Yes.
Yes, Mr. Ekene, are you there? Court registrar, call the next matter for ruling. Mr. Ekene, we are not hearing you. You need to unmute yourself. Can you hear me? Mr. Ebitola.
I can hear you, my lord.
Oh, okay. Mr. Ekene, call the next case. You need to unmute yourself so that we can hear you. Can the court registrar hear me, please? Mr. Ekene, you need to unmute yourself so that we can hear you. Yes, we're aware of the case. Mr. Ebitola, let me take your appearances, please, so that we can make progress.
S.O. Ebitola. Yes. My appearance for the claimant respondent.
Yes, is there any other counsel?
Can you hear me, my lord?
Yes.
Hello, my lord. Can you hear me?
I can hear you.
Suit number NICN/YN/203/2015 between Mr. Paul Chike.
Esther, what are you people doing there? Yes, is there any other counsel? Mr. Ebitola, I've taken your appearance. Is Mr. Okpala here?
There's any other counsel, my lord.
Oh, okay. This is the course ruling.
Can you hear me, sir?
I'm delivering my ruling. Please allow me to go on. This ruling is in respect of the defendant's applicant's motion on notice dated 4th of April 2022 and filed on the 5th of April 2022. One, an order of this honorable court granting leave to the first, second, and third defendants applicants to amend their first, second, and third statement of defense filed on the 19th of June 2018 by inserting the words, phrases, sentences highlighted and underlined in the first, second, and third defendants' proposed amended statement of defense attached herein and marked Exhibit A. 2, and for such further order or orders as this honorable court may deem fit to make in the circumstances of this suit. The grounds for the application are as follows. 1, that the claimant respondent applied to strike out the name of the original 4th, 5th, and 6th defendants from this suit, which was granted by this court. 2, that the first, second, and third defendants need to respond to specific allegations made by the claimant respondent in his statement of claim. 3, that the first, second, and third defendants applicants seek to amend their statement of defense to respond specifically to those specific paragraphs of the claimant statement of claim relating only to the first, second, and third defendant, with the absence of the 4th, 5th, and 6th defendants. 4, that the amendment sought by the first, second, and third defendants applicants does not raise any fresh issue or prejudice the claimant in any way, but rather meant to prevent the defendant applicants to present the defendant's applicant's case succinctly. And 5, the first, second, and third defendant's claimant shall rely on all the processes filed in this suit. In support of the application is an affidavit of 6 paragraphs deposed to by one Precious Moi, a litigation clerk in the law firm of Trice Noel Barristers and Solicitors, the solicitors to the defendant's applicants in this suit. Annexed to the application is one document marked Exhibit A, which is the proposed amended statement of defense. The defendant's applicants also filed along with the application a written address wherein a loan issue was nominated for the determination of this court, to wit, whether the applicant has placed official materials before the court to be entitled to the prayer sought. It is submitted on the loan issue that an amendment can be made at any stage before judgment is delivered, so long as it will not prejudice or overreach the other party to the suit, that the court has a discretion to grant an application of this nature, which will assist the court to determine the justice of the case. That since the amendment seeks to respond to specific paragraphs of the statement of facts, same should be granted in the interest of justice. References were made to the cases of Alawiye versus Ogunsanya, Yusuf versus Oyetunde, and Wabweze versus Naipost. Citations are given. In opposition to the application, the claimant respondent filed a counter affidavit of 10 paragraphs deposed to by the claimant respondent on record on the 22nd of April 2022. In the supporting written address, learned counsel proposed this single issue for determination, to wit, whether from the facts deposed to in the supporting affidavit and the counter affidavit, the defendant's applicants have made out a case that will warrant the exercise of this court's discretion in favor of this application. It was submitted on the sole issue that since the discretionary power of the court is an equitable remedy, it is not granted as a matter of course, but must be based on material facts placed before the court. Counsel referred to Atiku versus Yola local government. Citation is given. Learned counsel referred to Order 26 Rule 2, Order 26 Rule 5 of the rules of this court, and argued that the defendant's applicants did not file along with the application list of any additional witness or witnesses intended to be called, together with the witness statement on oath of the witnesses, as well as copies of additional documents sought to be relied upon. That this failure on the part of the defendant's applicants makes the application incompetent because rules of court are meant to be obeyed. Counsel referred to Burgeons PLC versus Geoffrey K. Daniel Kallio and owners of MV Arabella versus Nigeria Agricultural Insurance Corporation. Citations are provided. That even though the court has the powers to grant application for amendment of pleadings to correct errors and defects in such pleadings, the amendment sought in the instant application should not be granted because it will overreach the claimant respondent and further delay the proceedings in this suit, particularly since the claimant respondent has closed his case that the application is incompetent and same should be refused with cost in favor of the claimant respondent. Counsel referred to Campaign General de Geophysics Nigeria Limited and another versus Jumbo. Citation is given. Now cost decision. I have carefully considered the prayers sought by the defendant's applicants in the application. The reasons advanced for seeking to amend the statement of defense. The proposed amended statement of defense exhibited to the application, affidavits and written arguments of the parties in respect of the application. In paragraph 3, sub 1, 2, 3, 4, and paragraph 4 and 5 of the affidavit in support of the motion on notice, the defendant's applicants stated the reasons that necessitated the instant application as being that since the names of the SY 4th, 5th, and 6th defendants have been struck out of the suit, there is the need to amend the statement of defense filed on the 19th of June 2018 to reflect the remaining parties before the court. That since the application does not raise any fresh issue but aimed at placing all the material facts before the court, same should be granted. The law is right that the basic purpose of amending the court process is to correct errors in the said process so as to prevent the justice of the case from being defeated due to such errors. This is to enable the court to be aware of the facts before the reissues in controversy between the parties are determined. See John Oforishe versus Nigerian Gas Company Limited and Patrick Ezogbe Okolo versus Union Bank of Nigeria Limited. Citations are provided. Having considered the particulars of the amendment sought, as shown in the proposed amended statement of defense, Exhibit A, annexed to the application, it is noted that the defendants applicants, apart from seeking to amend paragraphs 4 sub 2 and 4 sub 4 to change the words 4th, 5th, and 6th defendants to Nigeria Union of Petroleum and Natural Gas Workers, NUPEN, Comrade Chinda W. James, Zonal Secretary of NUPEN, and Godwin Eruba, the Zonal Chairman of NUPEN, respectively. The proposed amended statement of defense also seeks to introduce new paragraphs 5 to 9, while the statement of defense filed on the 19th of June 2018 has 6 paragraphs. The proposed amendment has 11 paragraphs. I have also poured over the proposed paragraphs. The proposed paragraphs 5 to 9 sought to be introduced and discovered that the defendants applicants merely seek to plead court processes, including judgments in suit number NICN/CA/81/2013 and suit number NICN/YEN/46/2016, as well as the termination letter issued to the claimant dated 1st day of May 2012. It is pertinent to state that while the grant of application of this nature is at the discretion of the court, such discretion is not exercised as a matter of course. Such discretion will therefore not be exercised in favor of granting the application where the application is made in bad faith, if it will entail injustice to the respondent, if the proposed amendment will cause undue delay or is irrelevant or useless or merely raises a technical point, if the amendment has done some injury to the respondent which cannot be compensated for by cost, if the application is designed to overreach the respondent, and if the amendment will result in a party being confronted with an entirely new case at an extremely late stage of the trial or is in conflict with the evidence already given in the trial. See Chief Ade Dapo Adeke versus Chief Obi Akin Olugbe, citation is supplied. See also the case of Shell Petroleum Development Company of Nigeria Limited versus Kwame Amba, citation is also given, where the Supreme Court held, and I quote, where relating to the amendment of pleadings, the principle of law relating to the amendment of pleadings is that it can be granted at any stage of the proceedings, provided it does not introduce a new course of action or will overreach or is prejudicial to the other party, end of quote. See also Order 26 Rule 1 sub 2 of the Rules of this Code 2017, which provides that an amendment may be refused where it will A, present a completely different case or cause injustice to the other party, or where the application for amendment is brought in bad faith. B, necessitate the hearing of further evidence, especially on appeal. C, not cure the defects in the procedure sought to be cured, or where it is inconsistent and useless. And D, amount to overreaching the other party or an abuse of court process. Having examined all the circumstances of this application, I am of the humble view that since an application of this nature for amendment of pleadings can be made and granted at any stage of the proceedings, it is proper and just to allow the defendants applicants amend their pleadings in order to bring all relevant facts to the attention of the court. By Order 26 Rule 2 of the Rules of this Court, a party has no more than 2 opportunities to amend his pleadings, and this is the first application for amendment filed by the defendants applicants. I am therefore satisfied that the defendants applicants have given sufficient and convincing reasons in the supporting affidavit for the grant of the application. The argument that the application is incompetent because the law firm of Trice Noe barristers and solicitors no longer represent the defendants applicants is of no moment, because the motion on notice was signed by Okechukwu Okpala Esquire of Searches and Sears, Vantage Point and Associates, and Mr. Okpala has been appearing in this case since 2nd of May 2018, when the matter was at Owerri Judicial Division of this court. With the transfer of the suit to this court, Mr. Okpala started appearing before this court for the defendants applicants on the 16th day of December 2019. In the final result, I find merit in the application and same is hereby granted. The court therefore makes the following orders. 1, leave is hereby granted to the defendants applicants to amend their statement of defense filed on the 19th of June 2018 by inserting the words, phrases, or sentences highlighted and underlined in the first, second, and third defendants' proposed amended statement of defense attached to the application and marked as Exhibit A. 2, the defendants applicants are hereby given 14 days from today to file clean copies of the amended processes. The claimant respondent also has 14 days to file any consequential amendment. Ruling is entered accordingly, and I make no order as to cost.
As God pleases. Your worship, we are grateful. We thank you for your industry. We wish you all the best.
Thank you. You will have copy of the ruling when I get to Port Harcourt. Can you give us date? We can take date now.
Yes, my Lord.
Yes, give us date. Ibitola.
Yes, my Lord.
The matter is already for defense.
Yes, it's for defense.
Okay. Can I give us date for defense?
Can hear us?
Can you give us date for defense? Mr. Ibitola, they will communicate the dates to you.
It's mooted.
Yes. The new date will be communicated
As
to you.
God pleases, my Lord.
All right, thank you. Have a nice day.
As God pleases. Thank you, my Lord. Thank you, my Lord.